cannot object.
I just did.
You cannot.
I just did. I'm a lawyer. I'm a licensed, unblemished member of the bar. Unblemished. If you laugh at me one more time, we're going to walk out.
We're going to move for 30D3 sanctions.
We're going to move for harassment sanctions against you right now. Okay, you're laughing at us with the videotape that you published on the internet about you and your rock band, and you're going to be laughing at me. And you've moved for sanctions and had them denied every single time in this matter, and the jury should see that too. Every single one has led to no.
Denver, Colorado, March 2018. A conference room on the 14th floor of a building on 6th Street. A court reporter sits at one end of the table. A videographer checks the camera. Robert Abrams, an attorney and founding partner of Abrams Associates, takes a seat across from opposing counsel Thomas Burch. Abrams is not here as a lawyer today. He is here as a witness. His own firm is being sued for fraud. Burch.
Good morning, Mr. Abrams. As you know, my name's Tom Burch. I'm counsel for plaintiff Justin Moskowitz in this lawsuit. And do you understand why you've been asked to give your deposition today?
No.
Are you aware that your firm, Abrams Associates, is a defendant in a lawsuit that's going to trial next month?
Yes.
And are you aware that you are a witness regarding the actions of Abrams Associates?
Yes.
Have you had your deposition taken before?
I think so.
Opens with the simplest question a deposition can contain. He asks Abrams whether he has ever had his deposition taken before. Abrams says,
when have you had your deposition taken before?
I don't recall.
How many times?
I don't recall.
You're sitting here today under oath. You have no idea whether you've been deposed before?
I've answered that question. Object to form. Move on.
He doesn't recall. Burch presses. He asks how many times. Abrams says he doesn't recall. Burch notes for the record that Abrams is under oath. Abrams' own attorney, Sullenberger, objects to the form of the question and tells Burch to move on. Abrams, who is the witness and not the questioning attorney, joins in the objection himself. He says he has answered the question. The court reporter has nothing to read back.
Wow.
Mr. Abrams, have you been deposed
Object to
before?
form.
Object to form. Move to certify the question. If you feel that I haven't answered, then you can move for a sanction.
We're going to go ahead and stop the deposition at this point and dial the special master.
We're going off the record?
No, we're staying on the record, please.
Okay.
Would you be prepared to read back?
This exchange lasts several minutes over a question that most attorneys could answer in 4 words.
We're still on the record. Yeah. Mr. Abrams, I want to ask you one more time. Have you had your deposition taken before?
Object to form.
Asked and answered. Move on.
You need to answer the question.
The question was answered. Excuse me. Have her read it back.
Yep.
Mr. Abrams, this is not your deposition.
Please don't harass me.
No, I'm not harassing you.
We're going to move for sanctions
I'm
against
asking
you.
you to
If you're not
answer
going
the
to
questions.
allow
He just
her-
answered the question.
He did not answer the question.
He just said he did not recall. That's an answer to the question.
So it's your testimony under oath today, Mr. Abrams, that you do not recall whether or not you've ever been deposed before.
Asked and answered. And so please read
You
my
need
answer
to
back.
answer my questions, Mr. Abrams.
Please read the answer back.
No, do not.
The underlying lawsuit involves a plaintiff named Justin Moskowitz. Moskowitz alleges that Abrams and Associates committed fraud. A judge had already ruled before this deposition that substantial evidence existed to support that claim. The deposition is one of the last steps before trial. Burch needs testimony from the man who ran the firm. Instead, he is getting a procedural siege. Burch moves to the next question. He asks how many times Abrams' firm has been named as a defendant in a lawsuit. Abrams says once. In a matter involving a former client, he refers to only as BB. He describes that client in detail he did not offer for the earlier questions. He says the client attacked him in a stairwell. He says the client was belligerent. He says the client sued him and lost at a jury trial. Burch moves to strike the answer as irrelevant. Abrams objects to Burch's objection. He announces that he, as the witness, is moving to strike his own answer from the record. and then moving for sanctions against opposing counsel for harassment. An attorney in a deposition does not have standing to do
You're not
You can't
allowed
interrupt
to.
me.
I am allowed to
He's-
interrupt you. This
he's-
is my
he's
deposition
giving his
today,
answer.
sir.
You can't- it's
And
my
you,
answer.
it
This
is
is my
not.
answer.
You are not allowed to put objections on the record. You are a witness today, and Mr. Abrams, you are represented by counsel. Your counsel is allowed to put objections on the record. You are not today.
I am a lawyer.
Do you understand that?
I am a lawyer. I don't need a lecture from you who doesn't understand the rules of evidence. Under the rules of evidence, the only thing that can come in under the rules of evidence is truthfulness and untruthfulness. So to the extent that you're trying to disparage me because you have me on videotape and embarrass me for things that you can't bring in, I'm going to raise, move to strike, find it objectionable, and then move for sanctions for harassment under Rule 30D. You can look it up if you don't know it.
Mr. Abrams, I feel quite confident that if any sanction
either of those things. Burch reminds him of this. Abrams responds by telling Burch that he is a licensed member of the bar and that his license is unblemished. He says it twice within about 9
sanctions are entered in this matter, it's going to be against you
Objective form.
for continuing to obstruct and not answer any of
Objection.
my questions.
Objective
You
form.
cannot object.
I just did.
You cannot.
I just did. I'm a lawyer. I'm a licensed, unblemished member of the bar. Unblemished.
seconds. Burch then asks whether Abrams has ever been named in a criminal.
Aside from traffic tickets, have you ever been named in a criminal action?
Objective form.
Objective form and privilege. So I assert privilege and need not answer.
What privilege are you asserting, sir?
Attorney-client privilege, and we would, under the law, I need not answer that.
What law are you referring to, Mr. Abrams?
I need a law book. And I move to strike, and I move for, I move to strike the question. I refuse to answer under privilege, and I move for a
criminal action. Abrams invokes attorney-client privilege. Burch pauses. He asks which law supports that claim. Abrams says he needs a law book. He then moves to strike the question, refuses to answer, and moves for a protective order, all in the same breath. Sullenberger backs him up by asserting that Abrams had an attorney for any issues that may have arisen, and that attorney-client privilege therefore applies. The logic being offered is that Robert Abrams has attorney-client privilege over information about whether Robert Abrams was ever criminally charged.
Asserting today, Mr. Sullenberger.
Attorney-client privilege. He's already answered the question.
So Mr. Abrams is saying he has an attorney-client privilege over himself being named as a criminal defendant.
yes.
And the question's intended to harass and annoy. And under 30D3, again, we're going to move for sanctions for repeated conduct like this.
I can't even get through my initial question.
Because at some point Robert Abrams may have spoken to a lawyer. Attorney-client privilege protects communications between an attorney and a client. It does not protect the fact that a criminal action occurred. Every criminal arrest is a matter of public record. There is no recognized legal doctrine under which a witness can shield the bare existence of a prior criminal case from a deposing attorney. Sullenberger and Abrams
Ruled that there is substantial evidence against your firm that you committed fraud.
Objective
For misrepresentation of the
Are you
evidence,
aware?
Mischaracterization. The fact that the judge let you bring your bogus claim against us doesn't mean that it's merit full. Do you have a fraud question for me?
Please answer the question.
He just
again.
did. Ask and
I did.
answer.
Are you
We're
aware?
Yes, I'm aware. Move on.
Mr. Abrams.
both know this. Burch knows it too. The videographer continues to record. Burch asks about a bottle of pills Abrams has brought to the table and is visibly taking during the deposition. Abrams objects on grounds of medical privilege. Burch notes that Abrams filed a motion or
A couple more questions. Mr. Abrams, what are the pills that you just took? during this
Objective
deposition?
None of
form.
your business. None
Privilege.
What are those other pills?
Object to form,
your
object
business.
to privilege.
None of your business.
Medical privilege. Don't
Mr.
have-
Abrams, are you under any any drugs today? Have you taken any drugs before you came to this deposition today?
No.
Okay. Have you taken any alcohol before you came to this deposition today?
No.
Any medication whatsoever?
No.
No. Just these pills that you're taking here?
Yes.
That you are refusing to answer what they are?
Yes,
Medical
none
privilege.
of your business.
Okay.
But I can tell you that if you took some of these, they would help get some of your weight off.
Earlier in the litigation, arguing that medication he takes on long flights impairs his faculties, and that this was offered as grounds to quash the deposition subpoena entirely. Abrams confirms he filed the motion. He confirms the medication exists. He declines to say what it is. He invokes IPA. Then he tells Burch that if Abrams took some of the pills, it would help Burch lose weight. Burch asks whether the subpoena to compel Abrams' testimony was ever successfully quashed.
None of your business.
Okay.
But I can tell you that if you took some of these, they would help get some of your weight off. I can tell you that.
Oh, you're referring to when you called me fat when you walked in here.
Objective
I don't
form.
recall that.
You don't recall that? Okay. Well, we have a couple of witnesses to that, including Mr. Sullenberger. In any event,
If you want to raise your weight problem, Mr. Ward, with the jury and with the special master, please do. But we're not the ones that are sitting here in that condition.
Abrams says yes. Abrams is currently sitting at the deposition table. He is there because the subpoena was not quashed. He is under oath. He knows this. He says it anyway. The deposition moves to the question of whether Abrams was actually
And quashing you. That's my recollection.
are you here today pursuant to the subpoena?
Yes.
Okay. So your subpoena didn't get quashed, did it?
Yes, it did.
Sure didn't.
Yes, it did. Argumentative. Move on. What are you
and-
laughing at?
and-
Why do you keep laughing? What is it with you? Why don't you look at the camera and laugh at them?
Mr. Abrams,
You're
testimony
being
is being
obnoxious.
taken
Just
today.
ask me some questions about.
in town on a date. He previously claimed he was traveling, which had been the basis for an earlier attempt to reschedule. Abrams confirms he returned home at 3:30 in the morning on the day the deposition had been scheduled. He offers this as evidence that he was unavailable. He does not appear to register that returning home means he was home. Burch does not belabor the point. By the end of the session, Burch counts the questions that received substantive answers.
The special master that you were in fact in town.
Object to form.
We told the special master in a pleading that I returned at home at 3:30 in the morning on the same day that you scheduled my deposition, and that there was no way I was going to be able to come to the deposition with no sleep. We found
So you were in
contact
town
with-
at
Answers. He concludes that Abrams and Associates has no intention of participating in discovery and announces that all 3 depositions scheduled for that day will be suspended. He states his intention to bring the conduct before the special master and to seek
Mr. Abrams. In that motion, you included that Mr. Abrams' anxiety requires him to take medication on extended flights that impairs Mr. Abrams' facilities. Can you please explain what medication you were referring to in your filing?
Object to form
No.
medical privilege.
privilege.
Medical privilege.
Yes. Move
Yes,
on.
you have
What privilege is that?
None of your
Absolutely
business.
no right.
No, what medicine I take is none of your business. Move on.
You filed a motion with the special master saying that because of a certain medication that
Yep.
you take, you could not sit for your deposition.
Yes, that medicine's none of your business.
Right.
Move on.
And now
Objection,
you've
privilege.
come into this deposition today with a handful of pills
Yep.
that you refuse to answer questions about
Yes,
what they are.
None of your business. HIPAA protection privilege. Move on.
We are going to
full cost recovery, including special master fees. Abrams announces that he will file for the exact same relief against Burch.
move for sanctions against you and your firm for your conduct during this deposition, and we will take that up with the special master.
And will represent your conduct during this deposition as well.
Please do.
For the record, since the moment we've walked in here, I and my counsel have answered every single question and rightfully asserted 30D I think it's
30D3.
For harassment. We've answered every single question. We've asserted privilege where counsel refused to accept privilege. And we've been nothing but harassed under 30D3. We're moving for sanctions. We're moving to quash the deposition for future. And we're here to answer all of the questions regarding why my law firm.
The deposition ends. Nothing useful from either side's perspective.
In furtherance thereof.
We
Until
will
he
continue
does,
all three of the
we will
depositions
move
that
to
are scheduled
strike.
for today because it is very clear that Mr. Abrams, Mr. Sullenberger, and their firm intend to obstruct discovery in this matter and do not intend to answer the questions today. We will ask that it be reconvened before the special master with Abrams and Associates to pay the full amounts of everything associated with the depositions, including the special master's fee. And we will be filing a motion to take that up with the special master today.
We disagree. We're filing the exact same motion.
Has been placed on the record. Here is the single fact that stays with you after the tape runs.
The special master's fee, and we will be filing a motion to take that up with the special master today.
We disagree. We're filing the exact same motion and seeking the exact same sanctions. Anything else?
We will continue the deposition and go off the record at this time.
We're going off the record at 9:38.
Out. Robert Abrams spent 21 minutes refusing to confirm whether he had ever been deposed before. He is an attorney. He has practiced law long enough to have a partner's name on the door. He understands exactly what a deposition is. He sat in that chair and claimed under oath that he could not recall whether he had ever sat in a chair like that one before. That claim cannot be evaluated as ordinary forgetfulness. A person can forget many things. An attorney does not forget the experience of being examined under oath. The claim was not memory failure. It was a decision, and that decision points toward something larger than one difficult deposition. Legal procedure works because it assumes participants have a baseline commitment to its function. Objections exist to protect legitimate rights. Privilege exists to protect genuine confidentiality. Discovery exists so that trials can be decided on evidence rather than concealment. When a practitioner uses procedural tools not to protect a right but to prevent any exchange of information at all, the system does not automatically correct for it. The special master must be called. Motions must be filed. Fees must be sought. All of that takes time and money that one side, usually the institutional defendant, is better positioned to absorb than the other. Moskowitz, the plaintiff, was paying for that conference room. He was paying for Burch's time. He was paying for the court reporter and the videographer. And at the end of it, he had a tape that documented conduct but not testimony. The legal system gave him a record of an attorney refusing to participate in the legal system. The camera kept running the whole time. That, in the end, was the only thing in that room that did its job without interruption.